Okay, Ms. Cutler, when you're ready.
This is case number 22014-768CH. Mike Duggan et al. This is with regard to 2974 Calvert, Detroit, Michigan.
Council appearance for the record.
Good morning, Your Honor. Andrew Thomas, P679448, appearing on behalf of the plaintiff.
Okay, today was the date and time set for a show cause hearing, correct?
I believe it was for a hearing. A follow-up on the motion to withdraw as counsel.
Okay, and the court gave Mr. William Smith an opportunity to retain new counsel or come forward representing himself, correct?
That is correct.
And this matter was set for 11:30 and it's now 11:47 and no one has appeared on his behalf. That being said, what's your pleasure, Mr. Thomas?
So if you wouldn't mind, I'd like to show you a few pictures of the property. Let me see if I can do that before I promise to do that.
Do you have the ability to share your screen?
I believe I do. They moved all these things around again. Video participants, react, companion meeting, more. It's probably more.
Hmm.
Share, here it is.
Okay.
I'm sorry about that. It was right there too. So this is a picture of the front of the house.
And when were these pictures taken?
These were taken in June. Let me pull over so these were taken on June 10th of this year. I mean, it's also, I guess, one of the things that when I was doing my research that caught my eye. This is Google, and this is from back in 2022. But if you look right across the street, there's a really nice house, and out front is parked a stroller and a bicycle. So this is it's in a nice neighborhood where folks and children are living, and uh, so more attention probably to this than some of the other ones we bring before you is warranted. Here's the side, and there's one more somewhere in here. And then here's the other side. So this property is in pretty rough shape. It's open in portions to the elements.
And to your knowledge, nothing has been done on the property since then?
That's correct, Your Honor. And that would be consistent with our having been here 21 days ago.
Okay. And I don't recall, was Mr. Smith present at that time?
I was not present at that time, so I don't know. This was handled by I believe Giuseppe.
Okay, Mr. Palazzolo. Okay, so, one
That was-
noting that the court had given him an opportunity to appear with counsel and he failed to do so. This matter was set for 11:30, it's now 11:50, and he, or no one on his behalf, has appeared. The relief that you're requesting is?
The relief that I'm requesting is that the property be transferred to plaintiff That'll be it.
Uh, Based on the representations placed on the record, as well as the court having reviewed the pictures and noting that Mr. Williams was supposed to appear today with or without counsel, and this matter having been set for 11:30 and it's 11:51, the court is satisfied and the court will grant a judgment placing property in the hands of the land bank. And Mr. Thomas, of course, prepared the order and presented to the court for entry, and the court will sign the same.
All right, I'm grateful, Your Honor. Thank you very much, and I'll see you after lunch.
Yeah, see you this afternoon
All right, bye.
in person. Yeah. Stop sharing.
So can I say quickly, I'm gonna put Stafford in a breakout room so you can chat with those attorneys, and then the other two are for the record,
Okay.
Rivas and Rapari.
Okay. Yeah, they were supposed to have been here. Okay. Yeah, you can put them in a breakout.
Actually, the 10 o'clock was my error. I put it for 10 because I couldn't remember the time. It was supposed to be 11:30.
Okay. All
All
right.
right, I'll put them in the breakout.
Okay. And then we'll do Prevost.
Okay.
Okay, Ms. Clifton, we can do pre-votes.
Okay, Judge, I'm back. You ready on pre-votes?
Yes, I am. Okay, there we go. When you're ready, Ms. Clifton.
This is case number 24001544NH, the estate of Amelia Prevost et al. Versus Oakwood Healthcare, Inc.
Council appearances for the record.
Emma Hook on behalf of the plaintiff.
Stephanie Otten West on behalf of the defendant.
Okay, Ms. Hook, you can briefly put the terms. I understand it's confidential. I think it's a confidential agreement, so you can put basics on the record, and then you can void to your client.
Okay, thank you, Your Honor. Your Honor, the parties have agreed to settle this case. The defendant has asked this court for a confidentiality agreement, which my client has accepted. The details of how the settlement should be distributed are presented in plaintiff's motion to approve the settlement. The parties have agreed to the distribution of the settlement proceeds as laid out in confidential exhibit A attached to plaintiff's motion. My client has seen those numbers. All wrongful death heirs have been properly notified as required by statute and have waived any and all interest in the claim. Your Honor has appointed Pamela Mowry as guardian ad litem in this case. Ms. Mowry has recommended the approval of the distribution of the settlement. Will the court reporter please swear in the witness, Ann Curran?
I'll swear in. Wait, will
Thank
you
you, Your Honor.
raise your right hand? Ms. Prevost, do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Ms. Hook, you may proceed.
Thank you, Your Honor. You are the mother of Amelia Prevost and the personal representative of her estate, correct?
Yes.
And you have agreed to settle this case with the defendant hospital for the amount listed in confidential exhibit A, correct?
Yes.
At that time, were you advised by your attorney that you could either settle the case or go to trial?
Yes.
At that time, were you advised by your attorney that if you decided to go to trial, you could have gotten a bigger award, a smaller award, or no award at all?
Yes.
Do you understand that this is a full and final settlement against the defendant in this case?
Yes.
Do you understand that by accepting this full and final settlement, you and the estate will never be able to bring another claim in the future against the defendants regarding the same matter?
Yes.
Do you understand that it is in the best interest of the estate to settle the case?
Yes.
Have you reviewed the distribution sheet, confidential exhibit A?
Yes.
Have you seen the out-of-pocket costs and attorney fees pertaining to this case?
Yes.
Do you believe that such costs and attorney fees are reasonable?
Yes.
Do you want this court to grant the settlement and distribution of proceeds as laid out in confidential exhibit A?
Yes.
Does the court have any questions?
Now, in the confidential agreement, the parties listed in 6C, D, E, and F, those are siblings, correct?
Yes, ma'am.
Okay, thank you. Ms. Always, do you have anything you need to add?
No questions, Your Honor.
Okay. Ms. Hook, do you have anything else that you need to add at this junction?
No, Your Honor.
Okay, based on the representations placed on the record, as well as the court having approved the pleadings that have been filed, the court will approve the settlement and the distribution of settlement proceeds as it's outlined in Plaintiff's Exhibit A. Of course, I know you all will exchange the appropriate documents, and then the court will be presented with a stipend order of dismissal. Okay, is there anything else?
No, Your Honor.
Okay, thank you all. Appreciate your time, and I look for the order to be submitted to the court.
Thank you, Your Honor.
Thank you.
Thank you. Thank you.
Give me 1 second. I have to pull up this stuff on Wapari. Give me 1 second. Okay, we can bring them in.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon. When you're okay. When you're ready, Ms. Clifton.
Case number 23015858 N.I. Vakari versus Shabita.
Council appearances for the record.
Thank you, Your Honor. Paul Dillon appearing on behalf of the plaintiff, Harinderjit Bopari.
Good afternoon, Your Honor. Christina Corcus appearing on behalf of defendant Sheila.
Okay, and we have two motions. We have to quash the subpoena and to strike Dr. Habib.
And
Correct?
then a motion to quash the other trial subpoenas, Your Honor, with respect to the liability witnesses that plaintiff has subpoenaed at trial.
I'm sorry, what was the
There
last?
was a second motion to quash plaintiff's trial subpoenas.
Okay. I thought I just said, Miss Clifton, I had two. Do we have more than two?
It's just these two, Your Honor. I just wanted to make sure you had the two.
Okay. Yeah, the motion to quash and the motion to strike.
Correct.
Right.
I have certain concessions that might shorten us a little bit.
Okay.
With respect,
Do
based
you
on
mind, Miss Corcus? Do you mind? So we can
Sure,
hear.
that's fine, Your Honor.
so
Mr.
based on thank you, Your Honor. Based on the defendant's admission of liability in their pleading, the plaintiff agrees that Kamal Carr and the Verizon Wireless subpoenas do not need to go forward, and we do not intend to call those witnesses.
Okay, let me see. What does that leave us with?
That leaves
That
us
was-
with the police officers, Your Honor, which if the court will allow for me to argue that portion of it.
Yes, go ahead.
As this honorable court is well aware, we were before this court on multiple motions in limine, one of which included preclusion of any testimony, evidence, documents, and so forth of any officers or their police reports or any investigation. This honorable court essentially granted it in full should we admit liability, which we have since admitted liability. The officers weren't witnesses to this accident, Your Honor. They're nothing but individuals that came to the scene afterwards, talked to witnesses, and then proceeded about their way. I'm not sure what counsel would be asking that wouldn't be hearsay, but regardless, the court has already ruled on this and precluded it. And despite that, brother counsel has issued subpoenas to these officers for the date of trial. For those reasons, and consistent with the court's prior ruling, these officers, the subpoenas should be stricken. They should be precluded from testifying. And for having to file this unnecessary motion, I am seeking costs, Your Honor.
Mr. Dillon?
Thank you. Wow. Well, let's be clear on one thing. The admission of liability came after the issuance of the subpoenas. So,
Okay, so well then you didn't mention that when we were talking about the other issues. Because it should be the police officer should have been part of your agreement because she's admitted liability. So I don't see why you didn't mention it. That's why I gave you the opportunity to assert what you were going to.
no, I understand. But I think that the police officers do have relevant testimony and admissible testimony, and we did argue this, and the court did already allow for the police officers to testify as to what their observations were. Yes, it's true that their explanations of how they believe the accident might have happened or what the defendant said or any of those observations are certainly out, but they can testify as to the placement of the vehicles and what they saw. And most importantly, we need testimony to substantiate the pictures, because this court also allowed for the admission of photographs of the exterior of the vehicles. I need someone who's going to say that these photographs fairly and accurately depict the condition of the vehicles at the time immediately following the collision. And
That's not,
the police
it's not
officers are
relevant though. It's not relevant because she's admitting liability. So no,
Your Honor,
I allowed the photographs in at the time. That was before she admitted liability. She's admitting liability, Mr. Dillon. So no, photographs are not coming in now. Since she's admitted liability, and there's no need to have the police officers testify. The police officers could only tangentially testify to anything that related to any potential liability, what somebody said if I allowed it in. But at this juncture, because Ms. Crocus is admitting liability, police officers are not relevant. So I'm totally striking the police officers from testimony, the police officer's testimony from testifying, and the pictures. That was a liability issue, and she's admitted it. So the photos are out and the police officers are out.
Thank
need to
you.
make a record, Your Honor. I need to make a record.
Go ahead. I thought you did, but go
I-
ahead.
Yeah, no, I couldn't disagree more with not only the court's current reasoning, but also its recollection of what it had said with respect to the photographs. The photographs are not there to establish liability. They are there to substantiate the injuries that were sustained, to show that the mechanism of injury was such that it could have generated the injuries that are alleged in this case. They had nothing to do with liability. The purpose of them being allowed in this case was simply to show and to substantiate the plaintiff's testimony that they could have sustained the type of injury that they allegedly did sustain in a collision of this nature. So that was the point of allowing those photographs. That's the point of needing the police officers to testify
No, the
still.
police officer out. I'm done. The police officers are out. They cannot testify as to the mechanisms or anything. They came in after the fact. And like I said, I was allowing them for limited purposes, but the police officers are still out.
Your Honor,
Go
if you're
ahead.
going to allow the photographs, unless this is just allowing him to make a record, I would like to respond to that. But if you're going to
You
stick to your
can, yeah,
point.
I'm letting him make his record. You can respond.
Okay, Your Honor,
Wait, I think Mr. Dillon was not finished. Mr.
oh,
Dillon.
sorry.
Marcus did ask a good question there, and that is, are you saying yes, the exterior photographs can still come in to show the mechanism of the injury, or not?
I'm taking argument on that. Go ahead, make your position.
Well, my argument is that they're absolutely necessary to substantiate a fact at issue in this case, and that there was a collision that was substantial enough to cause the injuries that plaintiff sustained. And that I need a person like the police officer who was there who can testify that these photographs fairly and accurately depict the condition of the vehicles at the time of the collision. And
No,
and there
all right,
and I
let me
should
stop.
also-
Let me stop you. Let me stop right there. The police
course.
officers don't need to testify to that. Was your client can attest? Who took the pictures? For starters, we need to lay a foundation. Who took the pictures? You
I'm
got to
not
lay
sure
a
who took the
foundation to get those pictures in. Who took the pictures?
I'm not sure who took the pictures.
Well, you
I
need
would
to
also point
determine.
out,
Hold on. Let me stop you right there. If you
sure.
cannot lay the foundation, I cannot let them in under any circumstances. So there has to be a proper foundation laid to get those photographs in. And so, that's the first thing. If you can lay the foundation, then the next question is whether or not I'm going to get it in. So, one, if you're going to have to lay the foundation for those to even be considered. If the foundation is laid, then the next portion is really moot. And I'll let Ms. Cocos respond when you're finished.
Your Honor, if I may,
It's,
this honorable.
when I'm
Oh,
finished,
sorry.
just real quick. That foundation, Your Honor, is someone able to testify that these pictures fairly and accurately depict the condition of the vehicles at the time at issue. A proper foundation does not require establishing who took the photographs. It is simply, do these pictures fairly and accurately depict the condition of the vehicles or what they purportedly show at the time? That's the proper foundation. That's why I need a police officer to testify to them.
Ms. Cocos?
Your Honor, I couldn't disagree more, but I want to first start with the fact that this honorable court was right in line when it precluded the photos along with the officer depths, and this is why. Accident damage does not result in injuries. The fact that counsel is making this argument and wants to present that to the jury is mind-boggling, because that couldn't be more prejudicial to my client. Just because there's a large dent. My brother was involved in an accident a year ago, and if you would have seen the damage to this vehicle, I tell him every day, how you made it out alive with not even a single scratch is mind-boggling. So how is he going to put that in front of a jury? He has no accident reconstructionist. He has no biomechanical expert. The photos don't prove an injury. They are for liability purposes only. They should not come in, and neither should the officer's testimony. He hasn't laid a proper foundation for them.
Yeah, and like I said,
Response?
well, let me say my piece and then you can put, no, just because it was her motion. No, in terms of that, it's really more prejudicial than probative at this juncture, Mr. Dillon. And as Ms. Corcus has indicated, one, the damage does not necessarily equate with injuries. We know that's the fact. So that's why it's more prejudicial than probative. And additionally, you do have to, if you're going to lay the foundation, you have to determine who took the pictures. But I've already said, but even beyond that, this court's position is that goes to liability. She's admitting liability. So the police officers are out and the photos are out. Okay, so Ms. Crocus, as to the motion to quash, that's my order, that they're out for those reasons. And you can
Thank you,
say
Your
for the reasons stated on the record, but they're out, Mr. Dillon. As to the second one, I think it was Dr. Habib, was it? Go
Yes,
ahead.
Your
Go ahead.
This one probably couldn't be more frustrating than ever. This honorable court, again, and I think what's very telling is that brother counsel filed a response saying that my motion was essentially the motions in limine that were filed. And he's right, that they were. This honorable court granted the motions, but brother counsel doesn't seem to understand the court's ruling, is issuing trial subpoenas, is scheduling trial depositions of doctors and experts that were precluded by this court because they were never presented during the course of this litigation and during discovery. Dr. Habib, Your Honor, never treated plaintiff during the discovery period. Brother counsel himself at the final pretrial conference when we were in person admitted to that fact, that Dr. Habib never treated him during discovery. As we sit here today, Your Honor, I haven't received one single record with Dr. Habib's name on it saying that he treated plaintiff, diagnosed him with anything, that he physically examined him. Nothing. There has been nothing presented to support that Dr. Habib ever treated Mr. Bopari during the course of this litigation. Counsel is trying to bring it in by way of Dr. Chowdhury, quote unquote, consulting Dr. Habib. First of all, there's been nothing to present that, not even a phone call, which I think the rules of evidence require, showing proof that there is calls between the doctors. All there is Dr. Chowdhury sending a referral for plaintiff to see Dr. Habib. He never saw him. He never followed up with him, nor do I have any records to that effect. Mr. Bopari appeared for a deposition. Dr. Habib wasn't one of the doctors that he testified he had treated with. Plaintiff's witness list was filed. He filed an amended witness list. Never did he list as an expert Dr. Habib that would be testifying as an orthopedic surgeon at the time of trial. This honorable court already heard all of these oral arguments, issued 2 orders granting, limiting any evidence, testimony, or experts not previously disclosed. And now what plaintiff is trying to do at the 11th hour is essentially a trial by surprise, which this honorable court knows the case law and court rules prohibit that. For those reasons, I am seeking the court to, again, remind brother counsel that Dr. Habib, reference to him, to his diagnosis, any treatment is prohibited, will not come in. And again, I am seeking costs for a complete waste of my time when we could be spending it doing other things, considering trial is Monday.
Mr. Dillon.
Thank you. If the court had said Dr. Habib cannot testify, I think we all know that Ms. Corcus would have put an order together that says Dr. Habib cannot testify. This motion was before the court, and this court clearly limited what Dr. Habib is going to be able to testify to.
Which
He
order
did not.
was that? Did I specifically say Dr. Habib?
That was Dr. Chowdhury, Your Honor, because he's a family med doctor. That was not Dr. Habib.
No. It was with respect to any doctors that were identified whose records weren't produced, because again, and just to be clear, Judge, Dr. Chowdhury's records indicate that he had conferred with and referred the matter to Dr. Habib, the orthopedic.
But that's not good enough. There's no records from, let me finish, because I'm not going to go down this rabbit hole. there's no, and I talked about this before, and we said if it was not raised during discovery, it's not coming in. So there's nothing that indicates that there's any treatment by Dr. Habib during the course of discovery. So it is not coming in, Mr. Dillon. It is not. He is not going to be a witness. He cannot testify. He cannot. We went through this. I'm not going down that rabbit hole. I've dealt with this before. Dr. Habib will not testify. He is not coming in. There's nothing been presented that he was a treating physician during the course of the discovery, and it's not coming in. I told you last time I'm not opening Pandora's box, so that's moot. It's not. We discussed this at length, and I don't. We've got to go forward, and I'm gonna, Mr. Dillon, we didn't need to do this because we talked
Can I
about it.
please, can I
We-
respond? Can I make some
Can I-
argument on this issue?
Can I finish my statement? When we talked about this at length, ad nauseum, during our in-person final pretrial conference. And we talked about it at length, ad nauseum, when I gave you an entire afternoon for motions in limine. So I'm not going down this rabbit hole again. You got a brief opportunity to respond, but I'm not
Okay.
doing this, Mr. Dillon. We've
Again,
been there, we've
again,
done that.
if the court had ordered that offered those motions in limine, Habib could not testify, I can't believe this court wouldn't expect, given Ms. Corcus's aggressive and she's very thorough. She would have presented an order that clearly said Dr. Habib cannot testify.
No, but what I
That
said,
order,
stop.
that order was not presented
But
because
what-
that's not what the court ordered.
No, but what my order did say, and I remember, like I said, I've got 1,000 cases, but I do know that I very clearly remember that I said any doctor who did not treat during the course of while discovery was open would not be allowed to testify.
may I-
I know that. And he
I-
didn't, and we're not, because we've talked about this. And
May
I'm
I-
not going I'm not going down this rabbit hole. I'm not.
Okay, but I just need to make a couple brief points here. I understand the court's ruling. If that's where the court's headed, I get it, but I do need to make just a couple of points. One is in a record of Dr. Chaudhry, the record dated October 12th, 2023, a document that defendants acknowledge having and have had over a year. It says this is a record from, and I can show it on the screen if I could share the screen.
I don't need to see it. No.
Okay. It says to Syed Habib from Kawar Chaudhry, subject patient referral regarding her Indrajit Singh Bopari, right shoulder pain. Sincerely, Kawar Chaudhry, MD. Part of that transmission included the MRI from June 7th of 2023 that shows the rotator cuff tear. It's based on that. Now, part of what the defense is trying to do in this case is also say that Dr. Chaudhry is practicing outside of the scope of his specialty by accepting the diagnosis of a torn rotator cuff, of prescribing the conservative course of treatment with respect to physical therapy and the injections. And I think that it's imperative for Mr. Bopari's case that it be allowed to show that Dr. Chaudhry was being responsible and acting appropriately within his medical license when he is conferring with Dr. Habib with respect to what is going on with his patient. And so we are not only showing what Dr. Habib has to say, but we are rebutting accusations that Dr. Chaudhry is not performing properly within the scope of his practice. In addition to that, at Mr. Bopari's deposition in August of 2024, there was a line of questioning where Mr. Bopari was asked a question about whether surgery had been recommended, and this is at page 58, line 24 to page 59, line 6 of Mr. Bopari's deposition. He said, Dr. Chaudhry had scheduled me to talk to somebody, and they talked. After talking to me, they suggested the surgery. I don't remember the name. Question: surgery on what part of your body? Answer, was the right shoulder, rotator cuff tear surgery. Question, and you don't remember this doctor's name? Answer, I don't remember the name. It was some Beaumont doctor. And the record should reflect that Dr. Habib is a Beaumont doctor. And this and then finally, I want to point out that Dr. Habib has always been on our witness list with respect to this case. And we discussed the issues of whether or not anybody was identified as an expert or not. But it's also appropriate for this witness to testify as to his personal knowledge of what he discussed with Dr. Chowdhury. I'm not going to be able to get Dr. Chowdhury to talk about what was told to him because it's going to be hearsay. And so I'm trying to address that issue by getting in front of it and saying, hey, here's one side of the conversation. Here's the other side of the conversation that took place when Dr. Chowdhury and Dr. Habib had that discussion both in October and I think subsequently to that. So for those reasons, Your Honor, I think, and I would also point out, it's somewhat unusual that neither Dr. Chowdhury nor Dr. Habib's depositions were sought in this case. And, so what we're actually trying to do is preclude the plaintiff from presenting their case just because the defendant didn't want to take these discovery steps in order to discover how Dr. Chowdhury came about his opinion and what contribution Habib made to this, if any. So for those reasons, Your Honor, I think it's absolutely essential to plaintiff's case that Dr. Habib be allowed to testify and that this aspect of the defendant's motion be denied.
Your Honor, if I may, the court's going to
Yeah.
entertain that. I'd like to point a few things. Further counsel mentioned that Dr. Habib was listed on his witness list. There's a few points I want to make in that regard. First, as this honorable court is well aware, there were 6 plaintiffs in this case. One of the plaintiffs that has settled, in fact, treated with Dr. Habib. So if Dr. Habib was listed on the witness list, that is why, not because Bopari. So the misrepresentation to the court, I don't take lightly. Number 2, in plaintiff's witness list, which we attached to our motions, and I believe this motion, but it's been attached to the other motions the court has already granted, plaintiff didn't even designate experts, Your Honor. The witness list doesn't designate any experts. Instead, plaintiff just lists lay witness. And in response to our motion in limine, brother counsel himself admitted that Dr. Chowdhury would be testifying as a lay witness and not an expert. So now all of a sudden, he has these experts that he wants to bring in. Let me tell you what's happening here, Your Honor. Brother counsel knows he doesn't have a proper expert. He doesn't have a proper orthopedic surgeon to comment on the tear. This isn't about trying to get Dr. Chowdhury to talk about the diagnosis. Yes, absolutely. Dr. Chowdhury was treating outside the scope of his practice, and this honorable court ruled that he can't testify to that treatment because it's not within the scope of his practice. It's common sense. A family medicine doctor does not treat a shoulder tear. So what brother counsel is trying to do is a trial by surprise, prejudice defendant Shobita by introducing an orthopedic surgeon to relate the tear to the accident when we've had no records, we've had nothing to support that they ever consulted one another, that they've ever treated with one another. And to say that I didn't do the proper discovery, I resent that argument because respectfully, I don't need to take a deposition of a doctor that hasn't been disclosed. And moreover, I don't need to take a deposition of a doctor that's treating someone outside the scope of their practice because guess what? This honorable court agreed and precluded that testimony. So why would I waste my time when I knew at the end of the day that that testimony would not come in? For those reasons, I think the court was right on track. Dr. Habib should not be coming in as a witness. There should be no testimony with respect to any consultations because that is impermissible hearsay, and the court should stand by its ruling.
Right. And additionally, like I said, no, let me talk. No. It was her motion. I gave you a significant opportunity. So no. Really what the problem is there's a whole bunch of problems. One, as I indicated before, if the records weren't produced during discovery, then nothing was coming in. 2, as she's indicated, there was no expert listed on the witness list at all. 3, relative to Dr. Habib, there was treatment by one of the other parties, but there's no indication that he treated this individual. There's no records have been produced. There's been no support. Yes, there's a mention of a conversation, but that's it. A mention of a conversation is hearsay. So that's not going to come in. So I'm sorry. Dr. Habib can't come in. I'm sorry. I'm done. I'm done. And I'm Miss Cocos. I appreciate Zilla's representation and advocacy on behalf of a client. So at this time, I'm not going to assess any cost, but Dr. Beebe is not coming in. So Dr. Beebe will be stricken as a party because, like I said, he was listed on the witness list, but I made it clear before that if in fact there was no treatment, no records that were presented during the course of discovery relative to it, fine. What you've indicated, Mr. Dillon, was there was one mention of a blurb, but I can't allow an orthopedic surgeon to come in and testify when one, there's no evidence that there was any treatment, no records have been produced or anything. I can't, and I'm not at this juncture. So Dr. Habib will be stricken as it relates to, and I forget it. Me and Miss Clifton were talking about the pronunciation of
Your Honor,
his
if the
name.
court's gonna, if I may,
How do you pronounce his name?
you're talking about Habib, Dr. Syed Habib?
No, the plaintiff that's left.
Oh, Harinderjit Bopari.
Harinder Gent. Okay.
Harinderjit.
Render Gent. Okay.
Yeah, Harinderjit Bopari.
Thank you,
Thank
and I'll submit orders with respect to both motions.
Your Honor, with respect to the court's ruling, so Dr. Chaudhry will be testifying that he did confer with an orthopedic with respect to how he was going about what he was doing.
If
No.
it's wait, if it's in his record, he can't testify that what he's talking about. He can say that he referred, but anything beyond that is hearsay. Anything that they talked about is hearsay. So no, you can mention if it's in the record that he referred him, fine. But beyond that, he can't testify.
Yeah, all there is a referral. There is nothing about any discussions. That is not.
And that's what I'm saying. That's out. He can talk about the fact that he made a referral, but that's it. But what they discussed, that's hearsay and it's not admissible.
Um,
It's
okay.
hearsay. But you
But
can,
it
like
would
I
be
said,
hearsay. It would be hearsay if he's testifying as to what somebody else said. I'm just
And
talking about what he did.
what he did. What do you mean what he did?
What he did was involving an orthopedic in the process. He
Yeah,
did that.
that's just
That's-
another roundabout way to try and get Habib in.
No, I know he's not. He's not. Like I said, he can say he referred him and he can talk about the fact that he made a referral. That's it. He can't talk about what any outcomes. I'm gonna cut it off. I'm gonna cut it off. I'm
Okay,
cutting it
just to
off.
be clear, Mr. Bopari did testify that Dr. Chowdhury had told him that he had had a conference with this orthopedic and that they suggested that there be a surgery.
That's hearsay too.
I
That's hearsay.
understand. I
But
understand.
and like I said, Dr. Chowdhury can say he made a referral, and that's it. That's it. He can't testify to what him and Dr. Habib. That's hearsay. So no.
Well, it would not be hearsay for him to say what he did as a result of that conversation, though.
No,
I'll
it's
take the-
out of the scope of his practice.
If it's, and we talked about that too.
My
If it's
God.
outside the scope of his practice, no,
I
we're
don't-
not going. I know, and we're not going to backdoor it, Mr. Dillon.
Well,
We're
Sheila,
not
Your Honor, I got to say something about this scope of the practice argument.
You ruled on that.
Dr.
No, wait.
Just a record.
No,
real
we're
quick.
not dealing. That's not before me today. I'm not
It's
going
been
down this
referenced.
rabbit hole. I'm not going down this rabbit hole.
I appreciate that, but we have not established what the scope of practice is for Dr. Chaudhry. And I keep getting
Dr.
hit with these.
Chowdhury, what's his specialty? What is he?
Well, that's just it, Judge.
What is he?
He's a family practice doctor,
Okay, thank you.
an internist.
Thank you.
Okay.
All
I
right.
mean, whether
thank you, Your Honor. I'm
what
gonna-
is or isn't in the scope of that practice is not for Dr. Corcus or myself to decide. It's for some expert or some person with knowledge to
You
say what
said
it
the
is.
right thing. You said an expert. You don't have an
That's right.
expert. You don't have an
I
expert.
don't need an expert to testify what the scope of my client's practice is. Okay.
Okay,
He
but
can
he's not,
testify.
but I know, so you keep on trying to get this orthopedic stuff in. You keep on trying. He's not an orthopedic surgeon. He's not, or he can make a referral based on something that he surmised. He can make a referral to orthopedic surgeon. That's it. I'm done. Thank you very much. I'll look
Thank
for
you,
the
Your Honor.
orders and I will
I'll
see
submit it.
you. I don't think I'll see you all before Monday, right?
Monday. Yep.
Yeah.
Okay.
Yep.
All right,
Thank
thank you.
you.
And I'll
you,
look
Your
for the joint final pretrial statement to be presented on Friday.
Sounds good.
Thank you,
Thank
Your
you.
Okay, thank you all. Have a good day.
You too. Bye now.
Bye-bye.